Hello everybody. Today we are going to discuss judicial recusal in the federal judiciary of the United States. Judicial recusal in simple forms means it's the judge who is assigned a case or is supposed to normally preside in a case who takes themselves off the case for certain reasons. I'm going to cut to the chase. I have major issues with judicial recusal. I do not believe judges recuse themselves, and I do not believe that the judicial system does the proper job of mandating what needs to be done when a recusal does not take place. Right now it's in the news because we're talking about Justice Wife possibly being in the middle of committing crimes and conspiracies having to do with overthrowing our government and infiltrating the Supreme Court, which is one of the areas which decides how the law is going to be figured out, and in fact did sit on a couple cases that had to do with that without saying anything. We're going to discuss that on another video. Today what we're going to mainly discuss is judicial recusal and some of the mainstays that you need to research and you need to be aware of in order for you to have an intelligent conversation about judicial recusal in the federal judiciary in the United States as of today. One of the most important things that you can do is you can go online, and I'll send a link, and you'll notice that it's the supremecourt.gov website of the implementation of the Judicial Conduct and Disabilities Act of 1980. In summary, Justice Rehnquist was concerned that the judges were not properly recusing themselves. This is the appropriate administrative task of the Supreme Court, as the Supreme Court of the United States not only handles the cases at the highest level for the federal judiciary, but they are also in charge of all the administrative tasks of all the judges underneath them in all the appellate and federal courts. Chapter 1. Committee Creation and Activities, Previous Studies, Acts, Provisions. Congress enacted the Judicial Conduct and Disability Act in 1980. The Act permits any person to file a complaint alleging misconduct by a federal judge or a federal judge's inability to discharge the duties of office because of a mental or physical disability, and describes how such complaints are to be treated. The Committee Creation. On May 25, 2004, Chief Justice Rehnquist appointed the 6-member committee to assess how the judicial branch has administered the Act. The Chief Justice said, "There have been some recent criticism from Congress about the way in which the Judicial Conduct and Disability Act of 1980 is being implemented, and I decided that the best way to see if there is any real problems is to have a committee look into it. See Appendix A." Chief Justice Roberts asked the committee to continue its work. Members: Chief Justice Rehnquist's appointed Associate Supreme Court Justice Stephen Breyer, who is the chair, District Judge Sarah Evans Barker of the Southern District of Indiana, Senior U.S. Circuit Judge Pasco M. Baumann of the 8th Circuit, U.S. District Judge D. Brock Hornby of the District of Maine, U.S. Circuit Judge J. Harvey Wilkinson III of the 4th Circuit, and Sally M. Meyer, Administrative Assistant to the Chief Justice. All appellate judges on the committee have served as chief judges of their courts of appeal and thus as chairs of their circuit judicial councils and members of the Judicial Conference of the United States. Both district judges on the committee had served as members of the Judicial Conference and of its executive committee and as members of their circuit judicial councils. Ms. Ryder was a litigator in the District of Columbia for 13 years, then served as Chief Justice Rehnquist's administrative assistant from August 2000 until September 2005, and she currently serves Chief Justice Roberts in the same capacity. Appendix B has biographical summaries for the committee members. And then it goes into staff and budget, the committee's assignment. Previous studies of the Act and its administration. The Act's administration has been the object of one major inquiry, that of the National Commission on Judicial Discipline and Removal, which Congress created in 1990 and which has filed its report in 1993. The Commission's statutory charge, size, and funding, and thus its report and numerous supporting studies, went well beyond our narrower mandate. The report and studies covered the various means available and potentially available to Congress and the executive branch in dealing with judicial misconduct and disability, as well as administration of the 1980 Act and related actions within the judicial branch. The Commission made various recommendations principally to the judicial branch concerning the Act, its administration, and related matters, most of which have been implemented. As to the Act's administration, the Commission observed it would be surprising if a rigorous evaluation of experience under the 1980 Act had been unearthed no instances where those charged with the implementation failed to treat complaints with the seriousness they deserved. The Commission identified such instances, but not many. The Commission based this conclusion on its own analysis informed by several research inquiries undertaken by the Commission, including Jeffrey Barr's and Thomas Willing's Federal Judicial Center study of chief judges' disposition of complaints and their informal resolution of allegations. We move on. It then goes over a flow chart of the process, illustrative rules and committee standards, complaints, The report is really long, but there are certain sections that I think are worth going over. Inadequate limited inquiries, page 45 of the report. Section 352A authorizes the Chief Judge to conduct a limited inquiry to determine where appropriate corrective action has been or could be taken, or whether the facts in the complaint are either plainly untrue or incapable of being established through investigation. A Chief Judge who encounters matters reasonably in dispute should not make findings of fact, but rather appoint a special investigative committee to do so. Section 352A authorizes the Chief Judge or staff to communicate orally with the subject judge, complainant, or witnesses and examine relevant documents in the case, and authorize the Chief Judge to seek a written response from the judge. Whether there was an adequate inquiry usually involved complaints dismissed as frivolous. In evaluating the dismissal of a complaint as frivolous, i.e. as lacking in supporting factual substantiation, the central question is, does the complaint allege enough to call for a limited inquiry rather than a single dismissal as frivolous? Most of the dismissals we discuss below are, like the allegations of a manipulated appellate panel assigned above, problematic, not because a limited inquiry would have suggested facts sufficient to merit appointment of a special committee. They are problematic rather in light of illustrative rule number 4, commentary's assumption that the Chief Judge will contact a third party if the complainant alleges an impropriety and asserts that he knows of it because it was observed and reported to him by a person who is identified. Doing so helps identify a small number of complaints that may merit further investigation, and even if a much larger number of complaints that turns out to be meritless, it helps make clear that the judicial branch takes complaints seriously. Thus, our standard force says that there should be a limited inquiry if a complaint that is not inherently credible and is not subject to dismissal on the grounds asserted that the complaint's allegation is supported by the transcript or by named witnesses, or sets forth allegations that are capable of being verified by looking at identifiable transcripts or questioning identifiable witnesses.